Hey, so in this video, I want to talk about 2 reasons why people transfer their out-of-state real estate into a limited liability company. Hey everybody, I'm Paul Ramley. I'm an estate planning attorney. You know, some people own real estate in their home state where they live, and then they also own real estate in another state. Not everybody does, but some people do. Family property, vacation property, whatever the case may be. So in this video, I want to go through 2 reasons why people often transfer their out-of-state real estate to what's commonly referred to as an LLC or a limited liability company. So the first reason people transfer their property to an LLC is the most often cited reason. It's to get that limited liability. And let me go through that scenario with you, because if you own property in your name in another state, maybe it's commercial property, maybe it's rental property, and someone gets injured on that property, well, because you own the property, they're going to sue the owner of the property, that's you. And if they get a judgment against you, and to the extent any insurance doesn't cover that liability, you personally are on the hook to satisfy that judgment, and all of your personal assets are going to have to be used to satisfy that judgment. It could wipe you out. So the idea behind limiting your liability is you transfer that property to what's called a limited liability company or LLC. You are the owner, or it's called a member of the LLC. Now you own an LLC, and the LLC owns your out-of-state property. And now if someone gets injured on that property, they're going to sue the owner. The owner is the LLC. And to the extent, you know, they get a judgment against the LLC, only that LLC's assets must be used to satisfy that judgment. So you may lose that piece of property, but all of your other personal assets will be protected. So that's one reason why people transfer their out-of-state property into an LLC. A second reason people do it is to, I'll just go ahead and say it, then I'll explain it. They transfer their out-of-state property to a limited liability company in order to avoid the ancillary probate. Now let's go through what that's all about. Because if you own property in a state that's not the state where you reside, then when you pass away, there'll be, if there's assets in your name, there will be a probate in your home state to transfer perhaps the home that's in your name, your investments to your heirs. But that probate that takes place in your home state doesn't transfer your out-of-state property. So your survivors, your family, will have to go hire another set of lawyers or a law firm in that other state to handle what's called the ancillary probate, the probate in that other state where you own real estate when you pass away. Most families, most survivors, kind of by the time they get to that, they're throwing up their arms and saying, geez, Pete's, how many lawyers do I have to work with? How long is this going to take? How much bureaucratic red tape do we have to go through? So some people transfer their out-of-state property to an LLC, and now they don't own property in the other state, that they own an interest in a company that owns property out of state. And that company can be transferred when they die through the probate in their home state, so there's no ancillary probate, no probate in another state except for their own. So sounds complicated, but if you get lost, just take a little break, you know, hit rewind or whatever, and watch it again. Now, I'll go through one other scenario, and because I haven't yet mentioned the fact that some people transfer their out-of-state property to a trust or living trust or revocable living trust, that too will avoid the ancillary probate. So some people transfer their out-of-state property to an LLC to limit the liability and also to get the probate avoidance. Some people transfer their out-of-state property to their living trust to get the probate avoidance. Now, maybe the best scenario or alternative of all that some people consider is if you have out-of-state property, transfer that property to your LLC or to an LLC, a limited liability company. And that will give you the limited liability and it will avoid the out-of-state probate. And then what some people do to take it to another level is they create their living trust, in their state, and they transfer all those probate assets, including that LLC, to their living trust. So then the LLC can be transferred when they die without even needing an in-state probate. So lots of layers of protection there and lots of other things to consider. For example, before you transfer your real estate, particularly your non-home real estate, to an LLC, you're going to want to check with your lender if there's a mortgage or a loan on the property to make sure that the due on sale clause is not going to be initiated by transferring a property to an LLC. Want to check with your property liability insurer to make sure that if you transfer the property from your name to your LLC, then you want to make sure that the insurance rates don't go up because they're requiring you to have some kind of commercial policy to insure the property. So check with your lender and your insurer before transferring property to an LLC. But having all that in place the right way can really, give you some peace of mind, give you that liability protection, make things much simpler for your spouse, for your children, for your other heirs, avoiding all the kind of government red tape that really frustrates a lot of families when they have to go through the court proceedings when a loved one passes away. So hope that helps. That's 2 reasons why people transfer their out-of-state property to an LLC, with kind of a final strategy mixed in there as well. I'm Paul Rabelais. Hope that helps. Have a great day. Oh, by the way, if you found this helpful, click like, comment if you've had some experience with this. Others will find it helpful, and also hit that subscribe button. Okay, that's it. See ya.